And welcome back, folks. This is Joint Justice Oversight Committee. It is September 9th. It's our afternoon meeting at 1 o'clock. And we're going to start out with getting an overview of, getting an overview of the victim notification system, but also there is a victim notification task force as well. We have in our packet at number 64, which is a statute. The front page says current time, but if you go to the second page, on section 28, it talks about the victim notification system task force. And this came about as a result of work that was done in my committee, looking at the issues with the fine system within DOC, as well as working with the state's attorney's office and the crime victim services as well, and really trying to get the folks together to look at improving victim accessibility to the information, ensuring that the notification process is trauma-informed, and expanding the use of automatic notification systems and any recommendations for necessary training and resources. So that's what was put in place. Last session, the report is due November 15th, and the report is to us in terms of any proposed legislation that we may. I think it's really important for us to get overview and background of the victim notification system and how it operates. We tried to have as many of the players, major players here today. We tried to have DOC because they're the ones who operate the fine system. They were not available today. So we'll take this issue up again at our next meeting in October. The fine folks from DOC will be available as well as the other partners here. I'm not exactly sure how to get started. I would think either starting, I don't know, Isaac, if you wanted to weigh in at all in terms of what the fine system is, or if I should start with Jennifer.
Go together too if you want.
You and Jen can come up together. So you two want to start?
Please. There's two chairs and I would have felt lonely. Jen.
Thank you.
So welcome, folks. And if you could both introduce yourselves for the record. And I know that we have documents here, both from Tim, have from you, the Department of State's Attorneys and Sheriffs, and we also have from the DOC in terms of their victim survivor services and support, their policy for this. So that's a document. And I think it's, I'll turn it over to both of you folks. Welcome.
Good afternoon. Thank you very much. For the record, my name is Jennifer Pullman. I'm the Executive Director of the Vermont Center for Crime Victim Services. And also I have the honor of serving as the chair for the task force group that you all created last session.
Tim Leaders-Dumont, Executive Director of the Department of State's Attorneys and Sheriffs. And our department, in terms of this conversation, employs the 26 victim advocates that work in our 14 county state's attorneys offices that work on the pending cases in our criminal system concerning victim required rights and notifications.
So there's two systems here, basically.
At least.
Yeah. There is within the state's attorney's office when they're working with the victims going through the criminal justice system, going through the court system. And then once the person is sentenced, then it shifts over to the notification system within DOC, which is called fine system. And then the question is, how do those two systems talk to each other? How do they connect? And does the victim get lost in the middle for that. So there are two systems out there. One is pre-adjudication, the other one is adjudication.
The only nuance being law enforcement during the course of an investigation has responsibilities to the victim as well to inform them what's happening, the right to information. So whether it's state police, municipal agency, sheriffs, et cetera, the federal system has rights for victims as well. Even before a filing takes place by a prosecutor, there's rights that flow to the victim. So there's a handoff that takes place really from law enforcement to prosecutor to the Department of Corrections. So really, there are three systems that intercept points that happen across the victim communications.
And the goal is to make that as seamless as possible.
You're working on that. It's quite a task. I want to proceed.
Maybe talk about the history of it.
Yes.
Yeah.
As far as the background, I know that you all were here when we testified. By we, I mean the collective group that's been involved, testified in October, November to give some of the issues around the what brought us to this place. Chair Emmons knows well how this all started. Really the focus on victim notification, which is an absolute right in statute. And cannot be stressed in terms of how important is that is. You've heard from survivors about the importance of being able to plan, peace of mind, being able to prepare. And you've heard that literally this could be life and death for many survivors. And so when the conversation first, I thought, started to focus on victim notification was when we discussed, or this body discussed earned time back in 2020. And to be quite honest, my predecessor did not reach out to victims. There was no victim input in that process. And when victims actually found out about the change in law, ironically, it was through the Vine system. And there was a huge outcry. And Chair Emmons and Senator Sears at the time said, wait a minute, we got to fix this right away. And you put that back, number one priority when you came back. And that made tremendous, improvements in what had passed. And also, you all were presented with this information that there was victim notification out there. There was an automated process such that victims would know what was happening. This came back up during Learn Time in 2024. And it was at that time that, thanks to Joshua Rutherford, I don't know what his title is now. He keeps getting well-deserved promotions, but he said, you probably should hear from the center. And Chair Emmons was very gracious with her time. And I testified that what you understood the system and how it worked is really not working. And here are some of the concerns that I hear from victims and survivors and from others in the field, including attorneys, victim advocates. And Chair Emmons and Senator Sears said at that time, we're going to put a little pause on any further reforms until we take a look at this and what is happening. And that is what brought the group of concerned individuals back to you in October and November for their testimony. Since then, Chair Emmons, again, especially, was very gracious with, between all the Capitol Bill nuances, finding time for what kind of became the victim notification, I felt like subcommittee, that their committee, in terms of the devotion of time. And we brought out two pieces that were attached in Act 64. One was the creation of the task force, and then one was the changes to earned time. And I want to speak at some point with gratitude to Representative Wood, who was the first person to flag that victims did not receive active notification the same way that offenders did. And there was a change that was made to law that reflected in that. And if there is time, Tim and I will speak, Attorney Beatrice Dumont and I will speak to that. Okay. So we have been moving, but I think, the background in terms of how we got here is pretty much those different pieces. Tim and his group department did a lot of background work, presented survey information about the utilization of Vine, the trust that their advocates had. And, again, the areas of concern, and then I want to make space for Tim to comment before I continue to go on because I could. But areas of concern that were identified back in October and November, and then most robustly to Chair Emmons' committee were a lack of information and communication that was being shared between the most responsible bodies that were involved. A lack of menu of options for victims who wanted to be able to choose what information that they received and how they received it. At one point, that had been the case, and then that had been changed so that it was either an opt-in all the way or an opt-out. For victims and survivors, choice is incredibly important, and we were looking to restore that. Our notification is provided in terms of the information and how it's delivered. Language was an area that was flagged. Currently, the language is only provided in English or Spanish. Those are not Spanish is not the predominant non-English speaking language in Vermont. Readability in terms of somebody who's either dealing with a disability and or trauma. Making sure that the information is provided in a way that is not just understandable, but maybe not just at the time when a victim or survivor is getting a huge packet at the time of sentencing, but maybe a check-in later on. Forms that were going out that were blank and lacked any information whatsoever, other than just saying that somebody was, it was just the case, but not the offender, not what the crime was. Sometimes that information was erroneous. It might be for that offender, but not for that victim on that victim's case. And, just the need for training and resources. So that's how we got to where we are. And I don't know if you want to have any more say in the background. I can speak to the timeline and kind of where we are.
Yeah, well, one thing just to note, the document that I produced, the Tim Leaders Dumont for the record, is from exactly a year ago with Joint Justice. So this survey is about a year old, but it still directs a lot of my perspective concerning some of the areas that we need to work on. So it's this document looks like this on your website with our seal on the front. And our victim advocates are very engaged, because one of the ways that I think the Department of Corrections will enjoy success on their end is if our victim advocates are espousing a sense of confidence in the notification system that will be used at conviction, keeping in mind that our victim advocates have 600 cases per victim advocate, which is incredibly high. And let's say that you're working with, of that 600 cases, maybe you're working with over 600 victims. A lot of cases have one victim. If it's a homicide, you're dealing with a whole family. So it's a lot of communication. And we have 26 victim advocates, and they take a very personalized approach. Text messages, phone calls, emails, by any means necessary. If someone has a fax number, we'll try that. We exhaust all communications to get information to the victims concerning their pending cases. And we have their contact information. Sometimes it's given to us from law enforcement, and then we have that. Sometimes we'll update it. Hey, use this number, don't use this number, right? So that information has gone through us, and then we will encourage the victim always that they can use fines. And in terms of that post-conviction piece, I just wanted to insert it here because it's come up in all of our meetings. There's also a DOC to SAS overlay during the course of a pending case, and that's when someone's detained. When someone's detained awaiting trial, they're in the custody and care of the commissioner, but the case is pending. So it's sort of both systems are interacting at that point. And if someone makes bail, or and we'll talk about a little bit more later, transferred to another facility or is showing up to court, these are some places where DOC is involved, and the state's attorneys are having to inform the victims of what's going on with that person's physical whereabouts. So that's one of the pieces here. And for us to tell victims, hey, use this system, it's going to be helpful, we need to know that it's working and it's working accurately. And our victim advocates over the last few years have identified some areas where it's given them some pause. I would like to say that, Cassidy Renfro, who's here from DOC, is really working at the table, and we're going to be working on an MOU outlining SAS role, DOC role where there's overlap, and we're working on that now, as well as an exchange with our IT systems so that for those that opt in, victim information can be passed from one system to the other. That's very sensitive information because those folks are incredibly vulnerable to other types of collateral bad actors. So we're working on making sure we can work on that with our case management system. So we're working on those things. Yeah.
Can I just interrupt here? So in terms of the Vine system, I would assume the victim advocate in your wheelhouse victims are going to avail themselves of this. It's not an issue of opt-in or opt-out in terms of the state's attorney's victim.
In terms of us working with them, we don't have a Vine system.
Right.
It's all that personal approach. Yep.
Right, and the victims are going to be working with you. The Vine system, that is a victim notification system within DOC, is that an opt-in or opt-out throughout the whole system?
You have to sign up for it.
So it's up to the victim to sign up if they want to be notified or not.
And our folks help with that when someone is interested in signing up. Sometimes they are not thinking about signing up until sentencing, and sentencing is not like on TV. Sometimes there's 20 people that get sentenced in the same day. Victim may or may not be there, but is aware of it. And so that opportunity is a little bit more limited than people might believe. Yep.
So-
Sign up.
So at the courthouse, when a person is sentenced and the victims are present, how do the victims know that they are now going to be shifting over into another system, victim notification system? And how do they know that they can either opt in or opt out? How, where would that information, how would it be given to them?
Our victim advocates inform every victim that if a person is convicted, that the responsibility for notification will shift to Department of Corrections. And at that point, thinking about large majority of people who are convicted are not sentenced to incarcerative time in DOC. So if it's pure probation, conversation for a different day, which I want to put over here.
But if they're incarcerated, it's a sentence when they're incarcerated.
Yep.
The victim notification system that then kicks in is the Vine system, which is under DOC.
Yes.
And the victim has to decide, are they going to opt in or it's not an automatic opt-in. They have to make the decision one way or the other.
That's correct.
Please.
Just a quick question, Tim. I'm just, you had said at the outset that I'm sorry. Sorry, I had this off.
Very nice.
Yeah, it was very nice.
All needed that.
Sorry, lost my train of thought there for a minute. That there's variability in the victims advocates perceived value of the Vine system.
Yeah.
And so I guess I would wonder then how well that description of what the Vine system may or may not offer to a victim at the time where somebody is sentenced and is, being handed off. So it seems like there might be variability in the description of what they may or may not receive through that system if there is a lack of confidence or appreciation for the system. And that would seem to not be helpful to victims.
Yeah, I think it's true. If I was a victim advocate and I've experienced an erroneous notification, for example, person A is out when they're not out, which may cause me a mental breakdown. If I was a person experiencing crime, that would give me pause and saying, hey, and I might just give that warning. Hey, occasionally people try their best, but these notifications have from time to time had errors. We're working on all that now, which is why the task force is really setting up, doing 2-hour meetings whenever we're meeting we take up all 2 hours every single time. And I serve on the task force for the department and a number of victim advocates attend well. So we're constantly trying to inform, hey, this has come up, including specific notifications where we've seen an issue in the past, taken screenshots and provided all of those to the Department of Corrections. Hey, here's an area where we've seen a notification run into an issue. So we're working on that now, I think, because of the directive from you all to say, hey, there are some issues. And so we're trying to increase that confidence now so that the information that we're giving to victims, and we give it to alleged victims, both at the time that we receive the case as well. So when we're doing an initial onboarding with the victim, we give them information about Vines, in part because someone may be detained prior to conviction if they are convicted, and there's going to be that DOC custody that kicks in. So we give them that information, particularly for people who are held without bail or held on bail initially in our more violent or serious cases, risk of flight for the bail and for the hold without bail, the two constitutional allowances.
And is there I'm not in this might be actually a DLC question, I'm not sure. how does DOC receive information to make sure that the information that they then have in the Vine system is up to date? You know, so if there's a court action, what's the lag time between when it goes from the court to DOC, and who's responsible for transferring that information? Is there a a system where that's sort of done automatically, or is that something that relies on human contact to forward to DOC? I'm not sure how DOC receives the information. And
Post-conviction, if someone has signed up for the system, their contact information is in Vines and the person's been convicted, DOC would be responsible, based on that contact information, to reach out to the victim. If the person hasn't signed up for Vines, the statute still says that DOC needs to contact the victim and let probation is coming up, or parole. Parole is the best example. Parole is coming up. There's going to be a hearing. We want you to know about it. You have the right to, speak, et cetera. If the case is not yet been disposed of, it's pending, they're in custody, it's all hands on deck. DOC is going to be able to know where the person is. Previously, we were receiving notifications about where they were located in the state and the DOC system. That recently ended, which is something we can talk about, which was not well received by our department. And we gave that feedback. It's all hands on deck. DOC needs to know where the person is, and then we can communicate to the victim, hey, that person is here. Another piece that's come up recently is whether or not that person is going to come to court. Sometimes if a defendant is going to be virtual, the victim may come to court. If the person is going to be in person, the victim may want to be virtual. That also recently stopped. And we're not in favor of that as well. And that's the type of feedback, good or bad, right, that we need to give to DOC so that they know how our victim advocates are experiencing changes that happen in the DOC system, even for pending cases. So even prior to conviction happening, it's that all hands on deck, in my opinion. And they may still call, if they had a good relationship with someone at VSP who was doing the victim work, Amy Farr, they may call Amy Farr, who was the victim advocate for VSP, and say, hey, what's going on with my case? So it has to be all hands on deck. And when the victims are involved, they don't care who in government is responsible. They just want to know the information, know that it's accurate. So in my opinion, we can never fully rely on an automated system, and we can never fully rely on just people to figure it out. It has to be that overlap with information being transferred and best practices for automated messages. But we can't rely on just automated messages, in my opinion, regardless of where you're at.
So in a scenario where a person is detained, and say they've been detained for 6 months, a year, whatever, pending, is the Vine system at that point an opt-in or opt-out still?
It will entirely depend on whether or not the victim has said, I want it.
Even for the detainee, it's up to the victim. And how does that information get out to the victim? I mean, you're talking about 3 different notification systems: state police, state attorney, and DOC. And we're aware of those differences. We're aware of the different departments and what they do. The average citizen sees it all as one thing. How does that get translated to them? Yes, here's a victim advocate state's attorney that you've been working with. But once this person's incarcerated, either as a detainee or sentenced, it shifts from us to DOC, and then you have to make the decision as a victim whether you want to be notified or not. You have to work through DOC. How does that get? I know you said you're talking.
I want to let Jen respond to a part of that.
When
in terms of our statutory duty, it's to the victim with the best information we have. And if we don't have something from DOC, we'll go to like a offender locator and try to find persons in this facility. They're still there, right? That's what the current, one way that a human being can look online and say, where is this person located? And that's a good system, knowing where people are at located. In terms of that information crossover piece, I think we kind of all hold it for a while during the pending phase and the charging phase.
And if I may, Madam Chair, that is one of the areas of focus that we have taken on during our past 2, what I would call substantive meetings, is that there is also that gap between when somebody is not technically lodged with DOC, but they're held and then, or they might be released from court. What happens and how can we make that a better process? And it's been really great to have the Director of Victim Services from State Police on board, and we talked about this last week. And she's already started to, make some changes, working with her people. One of the pieces that we noticed was that we do provide a form for law enforcement to hand out, which essentially establishes or helps to, is a tool for them under their obligations to meet them under 13 VSA 5314. They have obligations to victims to inform them of their rights. And so we created a tool that was the center translated to 14 different languages. We had Disability Rights Vermont look at this tool. It helps law enforcement to be able to meet those obligations. What we noted when we looked at it was we don't have anything about registering for the VINE notification system. So we are going to immediately update some fields to make sure that we can do that. But also what the director of victim services at state police did notice was that in our conversation, there's not a real clear way to make sure that when somebody's booked and there is that package of information that goes over to booking, that victim information is front and center. And so she started working with, her officers to say, yeah, let's just make a form. And, Tim offered to roll it out to the sheriffs and to the chiefs, but like a form that would go right to front and center to say, here's the victim information. They are checking the box. They want to be notified. You heard from a survivor about what happened when her person was released. And she had no information about that and what happened to her. So that is something that we definitely are putting our attention into. And I'm very excited that within, 2 days' time, we already had a report back from the Director of Victim Services that she was on it. And so we'll have another report next week, but that's a gap that we definitely want to see addressed.
Tim, I'm just curious, when you referenced in your email about the changes that DOC made in terms of notification in a couple of different areas. And I'm just wondering, so in reflecting on what Chair Evans said, victims see, this is as one system, as the state, and so they, I would presume, want to be assured that, the state knows where the person is, where the perpetrator is. And is there information that perhaps the victims' advocates want to know that perhaps the victims themselves don't? So the victim, I just was thinking like the victim advocate might want to know that, somebody went from St. Albans to Springfield or vice versa, but the victim may or may not want that information. All they care about is that the person's still in state custody. Is that conceivable? And is the process that you folks are working through differentiating between victims and victim advocates? Because, they serve different roles.
Yeah, so and again, if you think about that fact pattern, if a victim has signed up for VINES, and if the case is pending, kind of an interesting status there. They want information. They've told us they want information from the Department of Corrections. And in their operating procedures, which Director Pullman sent over, it says on page 3 that they will inform if the individual is released from incarceration. Great. That seems basic and good.
Basic, yeah.
Is transferred to court, right? And as a part of what appears to be the suite of information that you can obtain, it was between facilities. I know of cases where a victim was located in a community and the alleged perpetrator was a community with a facility, purposefully not held in that facility to not be in close proximity to the victim. They were then transferred there. It's a huge problem if we don't have that information. If it's a surprise, we need that information, particularly if the victim has said, yes, I want it. So if they have not signed up for VINES or have told our victim, I don't want to know where this person is ever. I just want to know what's happening in my court proceeding. Then we cater our notifications to that need. Each person's treated whatever their needs are to accomplish those needs. But you're absolutely right. Some people do not want to know what is going on with the individual that allegedly caused the harm. And some do.
So I think you answered yes, that sometimes the victims' advocates want to know information that the victims don't necessarily, even about the same case.
Yeah, I mean, I wouldn't say the victim advocates want the information. They may have information that they're not going to pass on to the victim.
That's what I mean. You want to be, so
yes.
you want to be notified, even if that information is not transferred to the victim.
Well, you know, a perfect example, because I worked here in Washington County, is if there was someone who came in on an opposite end, but on a violation of probation, I would call PO Renfro and say, hey, is the person being held right now? Or did they just get re-released? Like, what's going on with this person? The victims, you know, and so it's that personal approach that we have to take. But you have to know who to call if you're in government. But you're right. There's information that victim advocates, anyone can look up offender locator. It's a public facing piece of information. But the other piece is whether or not they're coming to court in terms of something that just stopped recently. For the most part, right, I get it's maybe a piece of helpful information for most people, but it's a piece of essential information for the victim to know whether or not that person's going to be physically located in court that day. And it's great whether DOC tells us, hey, the person's not coming to court, we're bringing them, et cetera. Someone needs to know that information. It shouldn't be a surprise. So if the victim asks us, hey, is person X coming to court? We could say, no, they're not coming. Yes, they are coming. So those two changes recently, and I want to say I appreciate, I had asked formally when there are changes that we be officially notified in an official document saying these changes are happening. I was getting them ad hoc from the field. Now we appreciate that DOC will notify me specifically, these changes are happening, whether I object to them or not, it's a different topic, but I can send them out to the field. One piece of information, these changes have taken place. Please inform the victims that Vines will no longer do this, or Vines will do this, hopefully, with some things. So that is an improvement based on the work that we're doing here. Substance aside, I object to the fact that these two things stopped happening. It was a surprise, but now going forward, we'll at least know about those types of things and they won't be a surprise for us. I took the opportunity to talk about those two changes.
I see that. And we'll have an opportunity to ask DOC next month, I guess, about the impetus for that. Okay.
And I just want to add to Tim's comments that what was concerning was not whether or not, certainly I did not agree either, but was that the process of having this group is to make sure that we're improving communication and that this happened. Tim was, one of his advocates was informed in an ad hoc manner right after our meeting, felt, kind of disrespectful to the process that we're trying to create. So certainly happy that moving forward, there'll be a better plan for communication in that regard. But again, that was kind of our number one purpose, was to talk about communication and how we can be doing this better. So we're working through it. And,
Definitely.
Is there more that you wanted to share?
we can keep going, but I don't know what your time frame is.
I think we're mid process with the task force.
If we could just talk a little bit more about some of the other areas that we're focused on, and we don't need to belabor them. But again, that communication, information sharing, we're going knee deep next meeting into looking at the text of the notifications that are going out. That's going to be quite the work. Again, having disability rights look at these pieces, survivors, some of whom we've heard from, giving feedback and helping to really make sure that the directive that you all had passed is one that we're keeping front of mind in terms of trauma informed. And can we be providing better information when somebody's getting that notification that a person's being released? Can we be thinking about other resources? And I was just speaking with Cassidy Renfrew about this, other resources that we can include when you get that information, especially for a survivor, places to call if it's a domestic violence victim. Here's the hotline. Here's a resource. So we're working on those. That will take quite a bit of work, but I think that's one of the most important pieces, is figuring out what that looks like when somebody's in a place that they might not want to, when they might be getting something that's obviously going to be really upsetting. And also, restoring that menu option. And I understand DOC is working in another Vine side group to kind of continue that process, but restoring that choice so that victims don't have to be either all in for every single thing or get nothing, but I only want release, or I want to know if I might, if these midpoint review or different pieces that might come up. So how can we do those pieces? I heard that loud and clear from survivors that they would like those choices. And I believe that the state's attorney's advocates were saying that that's an important piece to bring back. And so working on that. We talked about the law enforcement role. So, we heard that loud and clear, especially in your committee, chairman. And we expect that that actually will be a rather quick turnaround and look forward to reporting back on that in November 15th, that we have adopted some pieces moving forward in a rollout plan. One of the other concerning pieces we found is that, and you all can appreciate this with legislation that you pass and you find out that nobody knew about it. We had done this great work to revise the form, but we still have departments and other offices that are using the very old convoluted, I think it's like a 3-point font form. So it's a distribution plan once we get it all ironed out.
Municipalities to stay nameless, right?
Well, I have another name I could drop, but I'll leave it be. It's not you. And then the other piece that we are starting to kind of focus on is the earned time change. Again, I wanted to just flag that because again, this really idea came from a comment that Representative Wood had mentioned, and we did change the law to make sure that victims would have the ability to opt in for active notification, no less than every 90 days. Unfortunately, what we found out was that there's been no meaningful rollout of providing that information to victims who are currently registered in binds as to the fact that they can actually get that notification. So that's another piece that we're working to implement, and working on the life of the case and trying to create something that's really nice and pretty for all of you when we come back officially in January, that can help us also to identify all the different places in the life of the case where we have already obligations and who's doing those pieces, and then where there are places like with the law enforcement pieces that we need to beef up. And so those are some of the tasks that we're talking about. I think that life of a case will really help us to think about also where there are obligations, whether or not it makes sense to kind of rethink where those obligations lie.
And as stated, I know because we have some members from Senate Technology Oversight here, we're working on working with DOC's IT staff to ensure that people would have a flag essentially in our system, and we could get that person who's flagged for an opt-in to DOC. Because maybe they've just told our victim advocate verbally on the phone, I want to know. And so that way we're taking that human approach, putting it into an IT system, and then it goes into an automated system. That's kind of that perfect example of seamlessness that we want to strive for. So we're excited to be working on that.
I have a couple of questions. You brought up the IT systems, and we have lots of experience in hearing from various departments. I'm sorry.
Sorry, Madam Chair. I didn't.
Sorry, yeah.
That was my question. How is DOC's IT system?
Well, yeah, not just DOC, you've got two IT systems, and that, I haven't, I don't know, maybe it's just the chairs we sit in here, but everybody tells us that, they don't communicate. There's not, and sorry, we can't make communicate. And so that would be wonderful if the interface could happen, where the information flowed back and forth and it wasn't always reliant upon.
We don't want any of their data.
Well,
I'm just kidding.
you do, but only in certain circumstances.
Yes, exactly.
Yeah. So that aside, that's not something I'm going to figure out here, but something, that you brought up in your memo, Tim, was, an MOU between the various parties. And I hope when you come back in November with a final report that you actually have a draft MOU. And that it's, with DOC, with VSP, with Center for Crime Victims, and with state's attorneys, so that we're not leaving somebody out, and if there needs to be somebody else in there that I didn't mention. But I think that's important because it kind of will, I think, help us get to the ultimate goal that the act is looking for, which is a more seamless system for victims in terms of their rights and their notification responsibilities, or the receipt of notification, and what each partner's responsibility is in that. So I'm just kind of putting that out as a challenge to come back in your final report with a draft MOU.
We'll get it done.
Yeah. Yeah, and I think it's going to have to stay fluid. Things will happen. We want to update it. So I think just making sure that, as you know, from your work, Madam, you have to make sure that MOU is really, really helpful, but it can't say stale it has to stay updated routinely. And yeah, I'd love lots of signatories to it, but I'm only going to obligate myself.
I totally get that.
Yeah,
I'm just putting out the expectation.
No, we're definitely interested in that. I know I've said MOU so many times the last few weeks that Cassidy is probably sick of it.
Well, it's, I think the other thing it does, it signifies respect for each entity's role in the process. When you all come together and say, we're going to do this together. And by not leaving, and hopefully not leaving anybody out, people are there together, and there is respect for each entity's role in the process. And I think sometimes it doesn't feel like that respect is there for some folks.
Other questions? So you're moving along, whoops.
I was very quickly, I don't want to get over my skis chair, and I think, we'll hear more from some Mark's subject matter experts next month, but I think the MOU is the proper change, really solidify those roles and patients. I think some of the friction in the system that I think really just stems from kind of the balkanized system we have in Vermont, our really peculiar system of unified system with a really short turnaround for folks who are in some of the facilities. And the Vineland system, as we've talked about in committee, it's very widely used. I think it comes out of the department's budget. I think was originally sort of intended for post-adjudication use for the sentenced population for folks reentering into victim notifications on that end, but it certainly has the capacity and capability to do pre-adjudication detainee notifications that help meet the needs of state's attorneys and crime victim services and law enforcement. But I think what Tim was saying, where there's those multiple intercept points, law enforcement, prosecutors, and so goes on to DOC, that's where we start to see some of those systems break down, where DOC might make changes that make sense to it because it's paying for the system, it's running the system, it makes sense for its side of the house. But sometimes I think we forget and don't communicate, to Tim's point, that some of those changes might have ripples for other folks who are using that system as well. So I think that's where we continue to, I think, have to participate in the task force and think about ways we can improve that work.
I do want to echo what Mr. Dano was saying around the different ways that Vine could be used. What thus far we've been trying to figure out is what lessons can we take away from how it has been used. One piece that was raised in a comment was, oh, well, in Kentucky, they use it, dispatch collects victim information and enters it. That was my reaction. And so we pretty much rejected that like as a group right away. I would say most of us anyway. It never made it to a vote because that's a whole new level of interaction that I don't think dispatch would be happy with. And I really have to think from a victim survivor perspective, gathering that information when somebody's calling 911. Is concerning. So we're thinking about different ways, and there are lots of other ways that we can use it. That was one that we felt comfortable going with Amy Farr's energy, with working with state police to say, this could be simple. This could just be a form, and we could alter one that's already being used. And then other ways that we can expand it, I think are certainly on the table. And we'll continue to do that. But I think we have a couple of pieces that it was clear to me when this committee, when your committee was having this conversation, when yours was as well, Chair Lund, that we've got some pieces that if we're going to expand it, we need to take away some lessons learned and fix what we already have been using or DOC has been using for 20 years and get these communication pieces very solid and some of that roll out.
Are you finding a cohesiveness among your state's attorney victim advocates? They all feel the same way about not getting the timely information from Vine, or they are getting the timely information from Vine, or how the two systems right now are working or not working? Is it pretty cohesive across all?
I would turn back to the survey we produced a year ago, which was pretty detailed. And I think was very well done by Chris Kasich, a former member of our department who master's degree in studying trends of this nature. So we were pulled on his skill set and putting it together. I would say that there was a lot of unity in the victim advocates core in our department concerning the need for updating vines to meet 2025 demands across the board. Because one of the things, and I know that DOC deals with this, is when something goes wrong on post-conviction, the person who they sometimes spent the longest time with was a state's attorney victim advocate. So they'll call us. And then we have to give that information back to DOC. Hey, this person is concerned about this or that. And so sometimes we are only hearing about the errors. We don't hear about the success of lots of notifications. I just want to put that out there. And so we look through the lens that we receive it. And so when we receive, hey, this happened to me, this happened to me, and I'll say I've had to tell a couple of our victim advocates, your job is not to do parole notifications, even though you like that person that works for victim services for DOC who asked you to call person X about parole hearing. Don't do it, because then that's a slippery slope of you doing DOC's job. And we can't have that. The MOU will be really good because I can't do it. This MOU, which is posted on all of our websites, clearly identifies what we're supposed to be doing when. That MOU will be helpful for new employees as well in our department as sort of a training document to hand off. Hey, this is where the lines are, and here's where we're going to overlap. So, but there's a fair amount of unity. There's a couple new victim advocates since we produced this report. I don't want to speak for them, but at the time of the report's survey, a lot of unity from our department.
I'm getting a text that we may not be on YouTube. I don't know. I've been getting,
We talked about IT too much.
yeah. We were on this morning, but not having a current meeting. So it shows live here.
Yeah, I'm fine.
It's live, it's live.
Do you want to have the person in the? Do you want to have the meeting?
No. Oh. I told them it was live.
It's live.
It's live.
I'll triple check with that.
Okay, great. Other questions?
Yeah, that is that too.
Okay, yeah, please.
Just
Wendy.
what, so the task force happened at a good time, obviously, right? And or do you have what you need to finish the work? And does what happened recently cause you to need something in addition or more time?
No, I'm very grateful that OC has lent two of their staff people to help me with the logistics and taking minutes. So that's very much appreciated. And now the recent changes don't, we're all in this together and trying to make it work. And I know there was a collective groan in some committees when I asked for another task force or work group or whatever they're called, because we still don't know why. But this is one that I'm even more steadfast in my belief that we would have gone back to our regular day's work and would have been lost in all the work that had been put in for 2024 and bringing this forward to this committee in October and November. So this is one that you can say, it's a good task force. It's accomplishing what it's supposed to. And we've got a lot of work ahead, but we'll provide some really meaningful pieces for November. And I just realized we are not disbanded until February. So you're stuck with it.
Well, and the reason that we did that, because the language came out of my committee, the reason we did that was so that we could get the report in November. And that was the thinking, well, then there could be some legislative work that needs statutes or things that need to be upgraded. And then if you're still in existence into February, then that helps us during the session when we start taking testimony. So that
And I think
it's still in place at that point.
we've uncovered a lot of issues and it is overwhelming. So trying to parse it out in terms of what is most immediate for the report for November, but then getting into what are some future pieces in terms of all the fruitful conversations and directions that we can go in.
So one of the members of the task force is the Commissioner of Corrections, replacing me. Now we have a different commissioner than we did when the task force first started. So who is the designee for the Commissioner of Corrections?
It's Meredith Pelkey, the Director of Victim Services. I would be hard pressed to imagine that would change.
So-
And then there's also another member that's appointed by the Commissioner.
Right, that's what I was on, I thought Mary
Who's
was.
familiar with the capability and technical operations.
And that's Joseph Bordeaux, and I would imagine he would not be replaced with the new commissioner, but I'm looking at Isaac and Cassidy.
That's my question, because
No.
it's a shift there at the top, which could mean it could be a shift.
They are still knee deep in other side groups with vines as well, and they bring those updates to us during our meeting. So I would think that Commissioner Murray probably has a lot of other things he wants to focus on.
Commissioner's probably got other things
Yeah.
getting up to speed on.
Right. We all know when there's a shift at the top, how things can change forward. Any other questions, thoughts? So we'll look forward to having you come in sometime in November, or December, based whenever we have our meeting in November, or December, when your report's ready.
Perfect. Looking forward to it. And again, thank you so much for your time.
And at our next meeting in October, we will be having DOC in to talk about Vine. So we'll be reaching out to you folks as well.
Okay.
We're hoping to have them in today. It didn't work on their schedule, but I decided let's keep going forward, give at least you two so we could get some background.
Thank you. Happy to be a fly on the wall.
Thank you.
What did you say, Nick?
I don't know. Leave or?
Back out town. Wow. So why don't we have a whole list of folks, so why don't we just take a quick 5 minutes? Put this on hold, don't take this offline. Just mute us. Okay, unmute us.
You are
And we're unmuted and let's get really focused here. We took a quick break. I'm waiting for transition to the next topic. The next topic is sheriff transports. And I don't know how many folks were aware, there was a report, was it 2 weeks ago, came out that there was a decision made from the Department of Sheriff's and State's Attorneys that deputy sheriffs would not be transporting folks from a correctional facility that was particularly detainees if they were being released. There would be no transport of that person from the incarcerated facility. That came about, I believe, a couple of weeks ago. I don't know how many folks had seen that article. I know we have talked, some of us here have talked over a number of years about sheriff transports, transporting folks from correctional facilities to court for arraignments, and back to the facility. But thought it might be good for the committee to get an update in terms of why this decision was made, but also the ramifications of this decision, because our facilities are not located. We've got a facility in Rutland, we've got a facility in St. Johnsbury. We've got a facility in Springfield, Newport, St. Albans, and South Burlington. So in St. Albans, they hold all the males who are arrested basically in the northwestern section of the state. So if they're being arraigned, it's video arraignment, and they are released, and they live in Virgins, or they live in Jericho or Underhill, and they're up in St. Albans, how do they get back? How do they get back home? If they're in Rutland, they could come from Arlington, Bennington, Pownell. How do they get back? So those are the questions that come to mind, and I thought it'd be good to have all the players here. We have DOC, the state's attorney, Attorney General. Just go down the list as it's ordered. We'll start with DOC first.
Only very limited comments, which is just to share your concern, share that transportation.
You just identify
Oh, yeah.
yourself. I said, why don't you come on up, because with you two, they may not be able to hear you.
Hi there, good afternoon again. Isaac Dano, I'm the policy director at DOC. I think, Chair, just very, very briefly, because a lot of this is sort of outside of our direct jurisdiction. I think this is an area of issue that we've been trying to solve for many years now, both on the detainee side as well as for sentenced folks, about how to get them transportation, particularly, folks releasing in the wintertime. And from some of our facilities, which are quite rural, Newport, St. Albans. There are instances where, we do give folks maybe a ride to kind of St. Albans city center area, but are pretty limited in our ability to provide transportation, beyond that, due to kind of liability concerns, as you can imagine. And also folks, once they walk out our door, sometimes, they're beyond our direct jurisdiction. So there's some statutory limits there.
So prior to this decision being made, what was the process? If you had a detainee, been there for, could be a couple days or it could be 3 months, and they had a video arraignment, then courts released them. What would be DOC's process at that point?
I think that I'd really defer to the state's attorneys and others kind of talk about how folks might move outside of the facility. But if someone is released from custody, maybe they have made bail, charges are dropped, they can walk right out the door of the correctional facility.
This is
For pre-adjudication, but also for some sentence.
the decision that was just made a couple weeks ago. What happened prior to Department of Sheriffs and State's Attorneys saying they're not going to do the transport. What happened prior to that?
So there was a time as it came to kind of court transports that DOC was doing that work. I think that was some years ago, and I'm looking at the Defender General. Before, I think it moved to some of the transport deputies. And I think we talked about this a little bit at the remote court conversation in committee, the joint session that we had. But of course, given our staffing levels, we have difficulty staffing our facilities, let alone transports. It's also been an issue, obviously, as we talked about this morning, with hospital coverage. And so I think I remember in that conversation around remote courts, that we also talked about the kind of addition of some transport deputies. But I think this is it's a really difficult issue we've been trying to solve for a while. I don't know this as a full answer. And then I'll let the state's attorneys speak more to the pieces around sheriff transports.
Well, if a detainee is being released, do they have access within the correctional facility to make a phone call before they leave?
Yes, I believe so.
And do they quite often do that? Do they have a contact person on the outside?
I'm sure it varies, but we also have, for the sentence folks, we have casework staff who help set that up. Sometimes kind of reentry POs, folks who are helping to kind of facilitate that. The 1115 waiver will, I think, also help in that regard with the VCCI case managers who will work to help set people up with appointments. And I hope also including transportation, that is so vital. We did, as a department, put out an RFP, I think 2 or 3 times to try and find a transport provider for justice-involved folks leaving our facilities. We weren't able to identify any bidders in that process.
Just generally, transportation is an issue for lots of sectors. And I just want to point out the women's reentry facility in Maine. Been to that a couple of times, and it is a reentry facility. But when you ask them what they wish they had done differently, they wish they were on a transit line. So I think I just want folks to be aware of the importance of transit, and we were looking at that, maybe are looking at that still when we're looking at the Essex facility.
Yeah, absolutely. I think that really gets to kind of the geography of our correctional system, that one reason why we really wanted to keep the women's replacement facility for CRCF somewhere in that direct area. We know that's where our service providers are, our staff live around there, and it's just a lot easier to get folks to where they need to be, including maybe employment. If it's a reentry center and they're going to be coming to and from, a lot of folks won't have access to a vehicle. And so that is one reason why we're kind of targeting the Chittenden County area. And that's based on the feedback from our stakeholder group, from our individuals themselves. But a lot of our men's facilities are not near an urban area in the state.
Often detainees released directly from a correctional facility all the time.
Or from court, it can be.
Thank you, Isaac. That wasn't too bad. Putting you on a hot seat. Tim, do you want to come on up?
Yeah. Team leaders, do you want to state attorneys and sheriffs right back with you? Well, talking about state paid transport deputies, we're state employees who work for our executive director's office for the Department of State's Attorneys and Sheriffs under Title 24. So context, right? We transported 4,035 people last year. 220 of those were post-release, which was the decision that you're talking about. It had largely stopped, and these are court orders from judges. That's how transport orders take place. We don't say, hey, we're going to transport, I'm going to use someone that I know here. We're not going to transport Senator Plunkett just because we feel like it. Judge has to tell us to transport Senator Plunkett. So 220 of 4,000 transports. Those post-release transports, if you think about what that is, and I say this having lived in a house with 2 public defenders, the history of people getting released from facilities is not a new phenomenon. During COVID, we started doing post-release because guess what we weren't doing? Those 4,000 other transports. And also there was quite a few people that left our facilities. So we had capacity to do a new thing that was also a health and safety thing. The only 4 counties where a post-release took place last year, there was 1 or 2 in Addison County. Wyndham was the number 1, and then Windsor, that corridor there, Wyndham, Windsor, and then Orleans, there was a few as well. So it was 4 courts that were still ordering these. When we informed the director of statewide the court administrator's office, they were shocked to hear that these were still happening. They thought they had stopped. And part of the reason that they were shocked and concerned that these were still happening, and I shared that concern, is that we are feeling so pinched. And with me is our director of sheriff operations, Tracy Patno, here with even the people who are detained, awaiting trial, and presumed innocent who are incarcerated or being detained. That has to be our core mission and our priority. The people who are being released, I wish we had 40 transport deputies to help with all of the different pieces of our system, but we have to prioritize people sitting in detention. Because if we're in the middle of a post-release, let's say a person lives in Brattleboro, they go up to Springfield, transport deputy then has to go back down to Brattleboro. They're not doing a transport for a weight of the evidence hearing or a sentencing hearing, that sort of thing. So we are at capacity even with our core mission, which is detained individuals awaiting court who are presumed innocent. And this practice, which I was a fan of during COVID, using our state employees to do health and safety activity. Sometimes family members did not want to interact with a person who had just been in a DOC facility because of COVID. So once we learned that there was still a couple hundred of these individuals being transported each year, we did make the decision in concert with the courts to ensure that it was stopping, to expand the little capacity we had. Those 220, we have a little bit more capacity for the people who are currently detained. And on a daily basis, there's a trial day down in Bennington today. We have 6 transport deputies of the 24 that we have down in Bennington today doing work. So that's one trial day in one county sets aside a huge percentage of our state employee transports. Looking at some of the history, and I know Defender General and I have talked about this, hearing 4,000 doesn't seem like a lot to the Defender General because it's actually not as much as we used to do. And that question as to why. We used to have, over here's our state transport deputies, our state employees, and over here's our pure county or per diem deputies. They used to pick up the slack. Sometimes it was retired VSP, sometimes it was retired chief of police that wanted to work in a county to help with transportation. So we could still, as a state, pay for that transport, but it wasn't a state employee. That has dropped significantly by a huge factor. We did about 22,000 hours on the road last year with our 24 state transport deputies, those positions. We're doing that pretty much every year consistently for the last 5-6 years. That used to be equal to our per diem state transport people that were helping with this. That's down to, 3,000 hours last year? It used to be about 20,000. Still 20,000 plus for our state employees on the road transporting people, but about 3,000 hours or so for the per diem fill-ins. That means we have the same level of need, but we have not expanded capacity, and we've had a drop off in the workforce in terms of those pure, when I say pure county, everyone knows kind of what I mean, paid for by the sheriff's contracts in that county. And I know Senator Norris can explain how that pressure builds up in a county when you're getting the demands from the court. You want to comply. The really excellent improvement that we've made in terms of some systems is with the director of statewide sheriff's operations. Part of her daily activity is assisting. County X needs help with this. I'm going to coordinate with this county, get this person over here. Some of our counties had siloed off a little bit in terms of how they worked in their transportation work. We are now working to break down those silos and pull a transport deputy from this county to help with this. For example, in Bennington today, we have transport deputies from multiple counties assist. So in terms of the change, I think it was an important change that I think we needed to make to have consistency across the state workforce for transportation. I took no pleasure in ending that program because I thought it was good at the time, but I was, I think, happy to prioritize our focus on detained individuals. I've been to most of the facility locations, and it is true that you can, if you are released, if you don't have a family member or your defense attorney, in some cases that I've experienced, waiting for you, you can walk right out of the facility because you're no longer in the care and custody of the Department of Corrections. So it is exactly as it sounds. They can walk out.
And I know last session, there were a few committees that were really to put more deputy sheriffs out, and that did not pass. I don't believe.
Representative Squirrel will definitely be attuned to that. We added one position, so we have a 25th position now, and Senator Lyons as well in appropriations, and Senator
We
Norris.
asked for at least 6.
Yes, we asked for 6. We got 1 additional, and our plan is to put that additional in Lamoille County. They did not have a state transport deputy in Lamoille County. Our plan is to put that 25th position there to help be a good swing location for the state. And we're actively recruiting for that position now. It's not funded. So why are you filling it? I'm filling it because during testimony, we were informed if you fill it, you could come back and hopefully during BAA get that sorted out. Our plan is to try to get that filled, and so we'll have 25 would be our hope, 25 positions out in the field. But it's true, 24 positions are funded, 1 is unfunded. We did ask for 6. We know that budgets are tight, but we do have that need, and part of it is because our pure county deputy employment in the field is not there anymore the way it used to. And you could survey the sheriffs as to the numbers they had 10 or so years ago in the county positions as opposed to today. Part of that is people are leaving the state in some regard, retirees that previously would be aged out of VSP that may have worked for us. I don't know all the reasons for that, but I know that the hours have significantly dropped off, and our director of sheriff operations looked into that for us. So hopefully that helped demystify some of the decision tree. Also, we have 127, last I checked, pending homicide related cases, 6,000 pending felonies and 23,000 pending criminal cases, with between 500 and 600 detainees. I know Isaac gave you the numbers this morning. Those detainees are going to be the individuals that interact with the transport team. We need to prioritize those folks first and foremost in terms of our daily activities on the roads. And it's a job that can really take much longer than you might expect, depending on logistics. Bennington to Newport is the most extreme example, but that happens quite a lot. And we try to be strategic about using our state resources, but it's a pressure pinch right now for us. We joked about Tracy and I getting level 2 certification to help out a little bit in the central Vermont area, but really we're working with what we have. And sometimes our sheriffs will also do transports themselves. So for example, here in Washington County, Mark Poulin, our sheriff here, is often involved in transportation himself as an elected sheriff.
Could you just expand a little bit on the connection between the pressures on the transport deputies and the increase in the detainee population from 338 in 2021 to 513 right now? Could you explain that a little bit further?
Yeah, so I think part of it, here we are 5 years plus out of COVID. We have dramatically increased our trials. Trials take many, many days at times, particularly for serious crimes. Those are, if you think about a state transport deputy staffing a trial, ensuring the person is brought there safely and brought back, that can be multiple days where they're no longer on the roads doing other types of activity for other hearings in other counties. So that's one piece. We've increased our trials. Trials take a long time if they're done well and if they're relating to serious cases. As mentioned, 3 years ago, we had about 90 pending homicides. We now have 120 pending homicides. So we have some very serious cases that we're currently working through. If you look up in Chittenden County, most of the time, the trials happening in Chittenden County are homicide trials. You're not seeing many other types of trials in some of our locations other than homicide trials, because we have to get through those to get to the other pieces. So in terms of the backlog, we have to work through the most serious cases first. Those take transportation because most of those individuals are detained. Once we get through that, we work to our sort of second rung of detained individuals. Let's say it sounds bad to say, a non-fatal aggravated domestic is less serious than a domestic that results in a homicide. So that would be the next piece. And those folks are going to sit until there's time in our facilities. There, of course, are certain constitutional provisions which say that certain trials have to happen within 60 days, for example. So that's another pressure. We have to push those cases through. If we're pushing those cases through, the cases that don't have that strict timeline are going to continue to sit until we move cases through the system. all examples of how violent crime pushes the backlog and the other cases that lie beneath further and further back. Our transport team is going to be involved with all of the more serious cases. For example, we might like to transport someone who has $1,000 bail and 25 pending retail thefts. Maybe they caused a lot of distress in the downtown in Vermont. Maybe they deserve their day in trial, and they do. But that's not going to get our focus until we deal with the violent crime that's happening. But that person deserves to be transported. We deserve to have time for those types of cases as well. But I think that it's related, and our lack of capacity on the county so I would say pure county per diem side means that our state team, our state employees are so busy doing what they're doing with the most serious cases that there's not a lot of extra capacity. And I have to say, working with the judiciary, they very much realize that, and we're working with them to ensure that if there's a status conference where if the person could be released, let's say they live in Chittenden, status conference is going to have to be in Rutland because they allegedly committed a crime down in Rutland. And they can plead out from the facility virtually. Why would we bring them down to Rutland when they could walk out and go home in Chittenden that day and resolve? So we still have to always use our virtual options where we can, where it makes sense for the detained person, because getting strip searched and going down to another location, another county can be terrible for the person involved based on the experience that they're leaving a facility, going down, sitting in a court. But we have to continue to utilize all of our options, virtual and in person. And in person has to be for those violent instances.
So to follow up, are the capacity issues with respect to transport deputies delaying getting cases resolved at all, or are you not seeing that?
You know, I'm looking at Tracy a little bit, our director of sheriff operations. I know there has been instances where we have had to have the state transport team call, or we would call the state's attorney's office or the court saying, what's the prospect of the person getting out today? We have a competing need in this other county for a violent case. If we're going to have a single transport team take person A down here, a person B down here, let's make sure we're using our resources appropriately. I think that it has allowed us to pause, say no, delay, or question more transports rather than saying yes to every transport order we get. We question more than we ever used to because of the capacity issues and wanting to prioritize, as I said. So I do think it's added to the backlog, even if it's hard to fully calculate how. Even if we said no in one case, we've added to the backlog. Or even if we've had a judge say, hey, let's wait on this case to transport this more serious case today.
Because we can't get the person here, or not, we're postponing about 2 hours.
And then, boosting our virtual abilities to have people do things remotely, because I don't want that to fall out of your scope of view. I know it's not in this room, but it generally needs to continue to stay an option for some folks.
But if they're on trial, they don't do it electronically.
That's correct.
They
That has to be.
in person. It's mostly the arraignments.
Yes,
Or
and
maybe the status.
yep, status conferences are a great opportunity for virtual, where mostly it's the attorneys engaging. Also, some change of plea events, like I said, where the person could get out, who's maybe been held on small amount of bail for a bunch of misdemeanors. That's a great opportunity to use a virtual option if they're ready to plead out.
So it works great for the court, works great for you folks, but may not, video arraignments or status conference may not work great for DOC. Because a lot of the facilities don't have the confidential space and you're pulling line staff off units. So it may work great for 2 of the 3 systems, but DOC is feeling an awful lot of pressure from that. So I just want to put that on the table for folks to be aware.
Right, and if we expand our transport capacity, we could say, I think part of it is sometimes I've questioned, and we've questioned certain transports saying, I've looked at these dockets. Does this person need to be transported today? And I don't think judges like that. I've never been held in contempt, but I've certainly been close because we don't have an unlimited amount of people or resources. Judge Donay hates it when I make that joke, but it's true. Occasionally we've had to make a call about, as an administrator, someone with a budget, I don't think that's a very comfortable position to be in. And I know, Your Honor, that you thought this was a good use of state time. And sometimes it's the attorney, and this is, and Defender General and I both talked about this. We know our defense attorneys are deeply overworked as well as our staff. And sometimes it's the first opportunity to meet in court. We don't think that's a good use of state resources to have the first meeting occur there if it's someone who's been detained for a long time. If it's someone who was detained on a Friday and their arraignment's on a Monday, totally understandable that you haven't met with your client yet. But as stated, I think that the best use of our time is to focus on our core mission, which has to be adult criminal defendants awaiting trial who are presumed innocent. If we're delaying their opportunity to get justice, we are delaying their presumption of innocence and really weighing against our better use of state resources.
Thank you, Tim.
Thank you very much.
Do you want to come on up? Defender General? At least you two have met more than one. Welcome, Matt.
Thanks for calling me, having us. This is, our systems are, I'm Matt Valerio, Defender General, for anybody who doesn't know. Those, I guess. These systems are so interrelated. You can't, nobody's pointing, I don't think anybody's pointing fingers at anybody particularly. And if they are, they're using all five. The transport issue and release from facilities, particularly for people who were lodged and then released, the vast majority of people are actually released at arraignment. They're not held. And in the past, we've had issues before this program that the Windham County Sheriff was really the prime mover of assisting people getting back to their home county when they're being detained in Springfield, primarily. Why were they in Springfield to begin with? This is where we start to, like that. I was just talking about one finger. Now I'll point the other finger, because now we have, since COVID, we have regional arraignments and video arraignments of people who otherwise would have been brought back to, Windham County, for example, been arraigned. And again, the vast majority of people are being released. They would have been released in their home county and able to get where they need to get. When we went to a video arraignment system and then regionalized it by putting basically everybody in Springfield who was going to be, that's when we started to run into problems. Similarly, in the Northwest, when people are up in St. Albans, so they get arrested in Burlington, now they're in St. Albans. And I don't know if you remember the kind of horror stories in the past where it's, 20 below zero and they just see you later, there's the door, you can walk out, not our liability, we don't want to deal with it. And those are rare cases, those are anecdotes, but they're also true. Those are things that happened. People with no ability to get from where they were released after their arraignment back to where they came from. There were some incidents in Springfield with some criminal activity of people. Bottom line is they were cold. They started pallets on fire, then they get charged with arson, and then the police chase them, so they run from them. It all builds on itself, and it starts that we are not being arraigned in the way we used to be arraigned in the county where the incident occurred. And we saw some of this even in Chittenden County relatively early on. Used to be, if you were arraigned in Chittenden County, you walk out on Cherry Street, and even if you aren't right from there, there's the bus station is right there, and there's people who can drive you places. We start to change that, and now people aren't being arraigned in the areas where they used to. So finger number 2 goes at the court. And that's the one, where video arraignments, which have plenty of issues beyond the fact that people are getting released and they have to walk out the door. I could go on for an hour just talking about video arraignments, which have been a bane to my existence from the day they started. And I think that, frankly, the vast majority of the judiciary itself doesn't like it. But they're here. We got to deal with them. And then when we end up with a resource situation, now sheriff's turn, where they don't have enough people to transport, to assist in getting people back to their home county, and they have to focus on what they can focus on. I don't blame them, but it causes these problems. It's a ripple effect all the way down the road. And from the defense perspective, and I'll point the finger, I don't know which one I'll point. I think I got to the wrong finger and I don't want to use that one. But these situations where you don't meet your client, you don't know who the client is, then the client gets released and you don't have any of their information, you don't know where they live, they've never seen their paperwork. And the like, it causes these other issues down the road that impacts like delays and other sorts of things. This transport issue is just like one symptom of a much bigger systematic kind of problem. And I'll point all of my fingers at all of us suffering the same issue, lack of a workforce. This past year, starting July 1st of this year, the public defense contract system, which represents about 40% of the total caseload in the state, shrunk by 15%. The remaining lawyers absorbed the caseload of the 15% who left. And that, because the lawyers don't exist to take the contracts. The bar, like our workforce in general, is shrinking. Those who are willing to do public defense work, I don't know if it's shrinking anymore, but it's at least shrinking proportionally to everybody else. And those people don't exist. So you've got less lawyers getting paid more, but doing more work, but you can only do one case at a time, so to speak. You're doing many cases at a time. But the bottom line is it slows down the whole system. When that slows down the system, these detainees are going to sit longer. One thing I did want to say, and I always hear this thing about the 130 or whatever it is, murders that we have out there. Those are not 130 murders. Those are 130 charges related to murders. There's the people who are charged with like the actual murder, if somebody actually was killed. And then there's usually, it seems to me, because I do all the assignments for all the murder cases in the public defense system, and we have almost all of them. There's 3 or 4 other people that are being charged with aiding in the commission of the murder, accessory after the fact with the murder, conspiracy to commit the murder. Sometimes there's, so don't get, I wouldn't want the press or anybody in the room to think that, we've had this like incredible explosion of murders. And now we've got 100 and something of them. We've had an increase, but it's not like that. Part of this is we've got a lot of people. This is a different, my experience over almost 40 years as a lawyer is different charging decisions are being made now regarding murders. So you end up with people who are getting charged with aiding, conspiracy, accessory, like that. And you're getting people who are now being charged with attempt. So attempted murders, and then there's aiding in attempted second-degree murder, because the elements are almost the same as, they're basically exactly the same as aggravated assault. In the old days, they might have charged it with aggravated assault. So some of these numbers are a little bit inflated. Not that they can't be charged with what they're charged with, but when I just wouldn't want it to be, people think, oh my God, we've had 123 murders since COVID. That's not what's going on. But with these very serious charges, these people are being held without bail. It adds to the detention population. And again, this ripple effect of impact on the backlog, delays, and all of these things that we're seeing. So, when it comes right down to it, I think that you can expect to see sort of collateral effects of the decision that's made not to assist people, who are getting released after arraignment, who have been lodged. You're gonna have some of those, because if you're in the middle of nowhere and you got to figure out what to do, problems are going to happen. And we saw it before. There was a good effort, but they don't have the people, they don't have the money. And it's something that I don't know the answer to unless you have more people and more money. It is all just, having been around a while, not just in this job, but before I ever had this job, it's amazing to me how we had a system where for 100 years, we could transport people to court and figure out how to get it done. And COVID happens, and in the entire system of doing that has been dismantled in 5 years, and actually less than 5 years, because COVID basically, the courts were closed for 2 years, at least for trials as a practical matter. So, the last 3 years, whatever happened during that time blew up 100 years of infrastructure. Before COVID, I was involved personally on 3 study committees, and then was a witness contributing member to a 4th on sheriff's transports and the effectiveness of those, and comparing other ways of maybe doing it. And one of the other things we looked at is DOC transports. DOC had a transport infrastructure as well. There was a time during my tenure as Defender General when they were doing 9,000 transports a year with their own vans and moving people around to facilities to deal with overcrowding issues and the like. That infrastructure doesn't exist anymore. I don't even think, do you guys even own a van anymore?
You got a couple kicking around.
Okay. But they used to have a fleet and to move people around. And part of it was getting people close to court. So when it was time for trial or a hearing that might be dispositive or the like, there was a coordination of that. That's gone away. Meanwhile, we also have the issues that the sheriffs are dealing with, where you have lost that infrastructure. So, we're in a much different place right now when it comes to resources, infrastructure, and people to actually do transports. And then you add on top of it sort of this regionalization of the arraignments, which puts people in spots they were never in before. And that's where we are. I'm not anticipating that there's going to be good results from where we are unless there's some significant change in how we do some parts of this system. Video can solve a bunch of things for people. One of the things it solves for defense counsel is you can have a caseload relief attorney from Springfield representing somebody in Chittenden County because they can do a status conference or a non-evidentiary hearing without having to travel, 2.5 hours to get to Burlington one way. And that makes that all workable. But when it comes to things like arraignments and release and trials and the like, it doesn't change anything. So, that's kind of where we're at.
Thanks for being so optimistic.
Well, it's, I wish I could tell you something better.
Yeah, I think we all do, yeah.
Yeah, I hate to be the guy to ask the question this late in the afternoon. However, you've been around for a couple of years, Defender General. I wonder if you give me a little history lesson here and tell me, when did the arraignment system via video come into play, and whose request, who implemented this system?
This was, there was a pilot project in Chittenden County to do arraignments, basically arraignments only, just before COVID started. And it was a couple of years before, but it was limited really to Chittenden County. And then it started to, there was a bit of expansion, but then it went full bore where everything went to video during COVID. And we are where we are. There's always been concerns, John Campbell, when he was the exec over at the State's Attorneys and Sheriffs, was like, this isn't going to work unless these people have like legit ability to meet with their lawyers, see their paperwork. People get released, they don't know what they're charged with. They just know that I've just been arraigned. So, but this started there. This was really pushed by various administrators at the court for a period of time. There was kind of a political battle going on within the court. I know that people couldn't even imagine such a thing, but there was a political battle going on. Some folks, one of the prior administrative judges, Amy Davenport, did not like the idea of video arraignments at all. And she fought it the entire time she was there. When Judge Grierson got in, he was okay with it. And it started to get legs during that time.
But I still, so is this a judiciary implementation? Is this by statute or?
Tradition.
It was definitely, judiciary did it by rule. It was actually, you might remember this. I actually advanced, and it passed both the House and the Senate, a bill that said that arraignments should not be done in video. They should be done consistent with the rule. And it passed both sides. And then the Governor Scott vetoed it. This was like very early in his tenure. It was really at the request of the court. But because it was, you folks as the legislature have the right to amend court rules, but you can't create court rules. So if the court makes a rule, you can amend it. That bill did that. But it got, I mean, I was pretty happy with how, I was stunned that it was actually kind of, that it ended up being vetoed. But I know that the court talked to governor's office and they, at the time, thought it was the right thing to do. So be it. We are where we are. But it hasn't been that long. But it's really fundamentally changed everything.
17, 18, something around that time. Was
Yeah. And the sheriffs, some of the sheriffs now, they don't have vans. They don't even have the ability, if they had the people, they don't even have the ability unless they're going to use a cruiser to transport somebody. So the whole infrastructure of our transport system that existed for 100 years doesn't exist anymore. It doesn't, from back when you were doing it, you wouldn't recognize it.
That's been a long time.
A little bit.
So just a follow up to that. So essentially there's not capacity right now if we wanted to go back to arraignments being in person only. There'd have to be some ramp up period if we were going to shift back to that.
I think I'd have to ask state's attorneys, but I don't know that they could. Could you guys transport everybody to ask them? I don't know.
We have the staff. That's a big.
I would want to do a better workforce analysis than available to me right now. We would need more state employee staff, or we would need that per diem county deputy corps to get built back up.
Is it fair to say that right now we don't have capacity?
That's correct.
We don't have the people capacity, but do we have the infrastructure vehicle capacity?
I don't know if we have even the number of vehicles. We don't have the same number of vans as the Defender General mentioned as we used to. A minority of counties have vans.
So do you need vans? So
It's better with like the trial day, for example, in Bennington today, if you have 6 people coming.
different trials.
Yeah.
Yeah, for it's a jury draw, not a 6 defendant trial.
This is the problem of having 2 prosecutors.
This would be a big trial, 6 defendants all the same.
I like it when they argue with you.
One trial with 6 defense.
No,
Jury draw.
but he has better information. Thank you so much.
And also the placement where the facilities are,
Yeah.
the way corrections is delivering services now, we're a unified system where we hold the detainees as well as those who are sentenced.
Yeah.
In the old days, that
Well,
was
now
your
you're going way back to when they had county lockups.
county lockups, and they were right there in the county.
That was,
But then in theory, with our correctional facilities, we were supposed to have regional facilities where you hold the detainees and they don't mix with sentence folks. Now, the system it's all over the place.
that though that's always, I came to Vermont, I went to college in Vermont and then came back in the late 80s to start practicing law here after I was in Massachusetts for a couple of years. But that's been the case really for a long time, I remember you would too, the Springfield facility when it was built, like everything you had to do to build a facility. You could probably build a nuclear power plant easier than trying to site a correctional facility in the state. And it, from a logistics standpoint, none of it ever made any sense. It was just like, who could we get to do it? And so that's how they end up where they are. And you also got to remember, we've closed facilities. So the Woodstock facility that used to be there is no longer there. And the farm is no longer there. And, you know, yeah. Well, yeah, I mean, we don't have any people there. So, you know, all of the capacity and, you know, there's plenty of issues right now with corrections regarding even capacity. I mean, I've got a briefing this morning from Prisoners' Rights Office that made my hair curl, and I'm gonna I'll talk to DOC before I, you know, get too far down that road. The bottom line is that, you know, the system is getting stressed from volume, from the inside out. And it's, you know, they can't hire people, we can't hire people, state's attorneys can't hire people. I hired a bunch of people, by the way. But this year to replace staff attorneys, nobody from even New England. I went to Memphis, Tennessee, Kansas, New Jersey, North Carolina, Florida. Like, can't hire anybody from Vermont or New England. I have to literally go across the country. It's not necessarily a good thing, but the New Hampshire public defense system is in some turmoil right now. And so they're kind of fleeing. So I hired 3 of them to fill vacancies from people who've left the staff system. That's not the contract system, totally different. But all of these stresses that we're having from a workforce situation, it's really killing us, honestly. The stress is immense. And that's why you see, you know, people leaving, honestly. They retire and they have to get out, like for their own health, not just, you know, I want to go do real estate or something. They actually leave the practice completely. They don't even just leave.
Or burnout.
Yeah, I mean, actually, serious health concerns. I had 3 people leave for serious health concerns, like doctors say you're going to have a stroke or you're going to do whatever. You know, you're going to have some serious ramifications if you don't dial this back and leave. They did it. So anyway, thank God for Kansas and Memphis.
Yeah.
Oh, here's that for you.
I think that, let me just make a suggestion or 2. I do think, let me 3. I think we have to dial back. Yeah.
Thank goodness it wasn't only me today.
We have to dial back, the video regional arraignments so that people can get arraigned in their own counties and get released, from their own courts. We have to dial it back some. Now, there's some, you know, if they're big murder cases and that kind of thing where people aren't going to be getting released as a practical matter. Now, you can never tell, but very rarely for a very serious case is somebody going to get arraigned and released at the first instance. But you can identify, you know, the people who got arrested for DUI and, you know, a domestic assault misdemeanor or those kinds of things. And you know they're going to get released as a practical matter. If they can get released closer to where they, you know, where they are being arraigned, that, or, you know, where they're from, that's better. So that should be dialed back. We need to increase the infrastructure that the sheriffs have to do the work. And I don't know that it's always about money, but I think this is about money. And sometimes it really is just about money. We need to rebuild the infrastructure that went away so quickly after COVID. And finally, we've got to put DOC back in the business of doing in their internal facility transports so that they can move people closer to where trials are, where lawyers are, where they're going to be released. And this is just rebuilding infrastructure that always used to exist. It's not like we're doing anything new. We might not have people who remember it, but I don't know how you can forget it in 3 to 5 years. But those two pieces of infrastructure and the things that cause us to put stress on that infrastructure, being the video arrangements being one of them. If we made some efforts on those parts, we could make some progress. I also think it would help with the kind of the quality of the work that's done both by the state's attorneys and by the defenders. When you have people who know what they're being charged with, know their lawyers, see their lawyers, and the like, as opposed to not.
This isn't actually for Mr. Valerio. Can I just ask him a quick question? I was just sort of reflecting on the resource issue for the 25th sheriff. And I'm just wondering, since you've had such a reduction in the per diem sheriffs, can't you transfer some of those resources that you used to have to pay there to pay for that sheriff? And when you said you didn't have resources, it seems like you have a significant reduction in what you've been paying out to those per diem folks.
I could look into that. But what we'd like to do is when we get 10 years 2 months for the record, is to keep the remaining capacity for what I didn't mention was extraditions. Most of the extraditions out of state today from same pot of money in the sheriff's budget. We like to know that we have money that's dedicated for a position that's a state employee position. So the 25th position, we're not going to rob from another budget line. Because maybe there's a great hiring spree that happens in our, on the private side of the sheriff's operations, and we don't want to limit our ability. We still want to keep that capacity. But I think it's a good question. I could go back to our fiscal folks, Annie and Barb, and see.
I'll leave it to Representative Tripp. To Representative Squirrel to ask that question.
Let me put it this way. We want to make sure we have money for the position, and that we're not stealing from some other location, but how we get to that point, I am all ears to get to that. Definitely.
Before I leave, could I add one thing?
Sure.
I had a note, the Prisoners' Rights Office asked me to bring this up since I was here. They do, as you might know, post-conviction relief cases and other civil cases on behalf of people who are in the custody of the Commissioner of Corrections. And given these same resource issues that the sheriffs have, none of those inmates are being transported to their post-conviction relief trials or other civil hearings, civil cases that they have with the court. Some of those, like with post-conviction relief cases, implicate a liberty interest at some point. While there's not a constitutional requirement of confrontation like you would have in a criminal case, traditionally they had always, if they wanted to, been at their various civil hearings. And it could be anything from post-conviction relief is like the biggest issue. But they have all kinds of other ones, like, they have divorce hearings, they have child support issues, they have conditions of confinement cases, they have other types of things where at times their presence and testimony would be required. And while you can do some of this stuff video wise, none of that is being transported, and it's pushed to the side because there's not a constitutional imperative of it, but regarding it, but the Prisoners' Rights Office sees it as, lesser quality justice, because there are times when they need to have them there and they can't get it. Even if they get a transport order, they can't get a transport. So it's a bit of, they asked me to bring it up and I did, and there's legitimacy. Like, I don't think that they have to go to every small claims case that they've filed, but there are other bigger, more important issues that are being litigated in Superior Court. That's an issue as well, but it's not a release issue, per se. They're civil cases, and so they don't really see the light of day when it comes to transports. Anyway.
Just to follow up with that, can you confirm for me that TPR, termination of parental rights cases, they are being provided transports for that? I just want to confirm that, but also that makes me think that, can we look at the different kinds of cases that they have in court, and some implicate higher level liberty interests, like losing your custody of a child or losing your parental rights, I should say. So we could look at fine tuning that perhaps a little bit.
Yeah.
But, yeah.
There have been some issues with TPRs.
We have a judicial money for that, if I may,
Yeah.
Chin's work group, we have about $50,000 that will eventually be exhausted, but we are paying for the TPRs through the judiciary right now.
So who would be requesting or making sure that that kind of money continues when we ask Trevor Squirrel to Squirrel? If that's money that's going to run out, but that seems to be the high end of a liberty interest, or of an interest, I should
The
say.
money is in the court. The court has the custody of that money.
So it's.
And so we agreed, my office, state's attorneys and the court, that where they can do it, that they would use that money until it's gone, or some portion of it, to deal with this. But it's a very temporary Band-Aid at best.
Never not. It's just not like that.
Yeah, there'd been, the reason that started is because there'd been some issues where they weren't being transported. And then we got together and said, hey, we found this money and it's supposed to be used for juvenile betterment. And yeah.
Is there a next level of the most critical types of cases that are civil cases that they should be transported? Because not to be able to accommodate it all, but maybe is there room to expand some?
And I think to some degree, it's on a case-by-case basis. I know post-conviction relief cases are one that they brought up, but not all of them. Some of them, it would not necessarily be required because the issue they're litigating over isn't something that the defendant would have to testify about or even comment on. There are all kinds of reasons why you might get post-conviction relief. So it's on a case-by-case basis, but post-conviction relief would be at the top of the list, and the family court cases would be this probably. I don't know which one is higher, one or the other. Clearly, we're kind of dealing with the TPRs, but for me, even above the PC, post-conviction relief, termination of parental rights would be more important even than that when it comes right down to it. All right.
There's a few million left in that fund still, so.
You think?
Oh, I know.
There's a few million?
Yeah,
Yes.
yeah. We've rated it once.
Yes. Tell Trevor,
They really have a few.
write that down.
It goes back a few years.
No, I know. I remember initially I thought it was like 7 million or something when it first started,
It's a few million.
but,
Maybe it's been
I wonder how much they have less.
More than 50,000.
Yeah. 50,000 is what we got, just put it that way.
Oh, yeah.
All right, thank you. And of course, if anybody has any questions, call me offline.
Thank you so much, and thank you all for this conversation. Don't know where we're gonna head with it, but at least it's informational. So Dan, do you want to come up real quick?
I guess.
I have another meeting I gotta go.
We're gonna keep this really short because it's after 3:00. We have.
I'm gonna do my best because this took me
We have Derek to DOC.
this took me an hour the last time I presented this joint committee hearing 2 years ago.
So, Derek, are you here for the post adjudication working group?
Yes, Chair Emmons, I am.
we've sort of quickly dealt with that earlier this morning, just in a real broad scope that the work is happening and the report's gonna be basic. So now we're shifting to something totally different. So I think you're free to go.
Okay, thank you for your time.
Nice to see you, Derek.
Thank you, Derek. So Ben, high level,
So do you,
I know you've been doing some work on justice reinvestment, the 9 yards.
so does every, I mean, I think a good opening question is, does everybody know what justice reinvestment is? I mean, I know some of you do. But I don't know, Senator Plunkett, okay. And Representative McFawn. So just very quickly, justice reinvestment was really a two-phased approach. It's a data-driven approach to improve public safety, reduce corrections and related criminal justice spending, and to reinvest those savings in strategies that can decrease crime and reduce recidivism. The initiative has largely been funded by the Department of Justice Bureau of Justice Assistance, with additional funding from the Pew Charitable Trust. The sort of administrator, if you will, of the program for Vermont has been the Council of State Governments. And for the record, my name is Ben Obroski from the Office of Legislative Counsel. So there have really been two iterations of justice reinvestment over the better part of 20 years. First one was in 2008, which created, I mean, I can get into very briefly the programs that were created, or I'll just gloss over it. So 2008, then there were some sort of interim measures passed, and the most recent one was in 2020, 2021, and the passage of Act, was it 148 or 142? 148 in 2020. Justice reinvestment has primarily been funded. So let me backtrack a little bit. So I said there are those two iterations. CSG has largely been the administrator and provided technical support for the programs. Their most recent recommendations were in 2022. And this is kind of related back to those next steps and community partners where they recommended reinvesting and making upfront investments or both when seeking to appropriate the funding in support of justice reinvestment 2 efforts. Those efforts are domestic violence intervention programming, data collection and analysis capacity, community-based mental health and substance use services, and criminogenic interventions with people with complex needs who are on community supervision, and housing-related needs for people on or transitioning to community supervision. The success of justice reinvestment in Vermont has yielded savings over the course of many years, and they've been identified as the primary funding source. So those savings are those out-of-state bed funds that we have talked about, where DOC appropriates a certain amount of money, expecting a certain amount of people to go to out-of-state bed facilities. When those justice reinvestment initiatives are successful and don't result in people going to those out-of-state beds, the savings that are accrued from that have been used and reinvested in other more rehabilitative, restorative justice approaches. Those funds were really the sole source of justice reinvestment funding. And for the last few years, up until I want to say 2 years ago, when the JR2 line item was created, Justice Oversight had the role of reauthorizing those appropriations that were made to DOC to reauthorize them for those restorative programming, if you will. That hasn't happened in the last couple of years since the justice reinvestment line item was created in the DOC's budget, but DOC funding for that initiative isn't the only source of funding for initiatives that people consider a part of justice reinvestment, even though they're really not. So for instance, the Attorney General's office has the diversion program, DCF has the barge program. Those are not considered justice reinvestment per se. But because they source from other programs or other funding sources, but they also receive, for the DOC administered programs, they would receive grants through that justice reinvestment line item. Whose brain hurts already? So this is a long way of saying justice reinvestment is complicated. The more success you have with these restorative programmings and the fewer people that go out of state, theoretically, the more funding and savings you would have to reinvest. However, I think it's largely understood that a lot of those savings are now being used for other purposes within DOC.
Right.
So it seems to me that, again, as I said earlier, there are no longer savings given the direction we're going as far as capacity and beds and all that. There are other savings that we're seeking to have through what you mentioned, the restorative justice initiatives that we have. Although we, at this point, have no way of measuring what those savings are, so they really can't be funding other justice reinvestment initiatives. As a general concept, we've been looking at ways to reduce how much money we're spending on incarcerated population. And the pie would be going up higher if we didn't have ways to divert people to treatment and to restorative justice practices. I mean, is that fair? I mean, that's how I kind of look at the whole thing, but it seems somewhat divorced from where it was initially, where it was really focused on bed savings.
That's the only way that you can quantify the savings.
Right.
Is the out-of-state bed contract.
And now,
What we're doing now, you can't,
You
it's
can't.
really hard to
You can't.
quantify.
and the irony of it all is that the creation of the justice reinvestment line item was what was to track the money. And unfortunately, since that line item includes things beyond the out-of-state bed savings, you really can't track it effectively.
Right. So there isn't, I mean, it's there, but it's not there, basically. Isaac?
Chair, I was just gonna mention, I think another issue that I touched on a little bit is that, we stabilized the pot of $900,000 of justice reinvestment money. Because like you were saying earlier, sometimes we 2 million, sometimes we 300,000, it's kind of hard to know what you're gonna do with the money if you're not sure kind of orders of magnitude. So we got it to 900,000, thanks to Rep. Squirrel. But the issue we kind of ran into is we found that a lot of that 900,000 was getting carved off as base. And originally the intent was for it to be one time, but a lot of.
That was the tug of war.
That was the tug of war, which we.
Yes.
And we figured that out. We, a lot of it, we ended up kind of carving it off as base. Now it is fully base, which I think does help avoid a lot of confusion. And in some ways, I think it's really helpful for our providers, our contract providers, our grantees like Lund, which is using the money that the last chunk that we carved off for the expansion of the Kids at Heart program for men, which I know your committee worked on in detail. So we're able to push that through, but that means that now all that 900,000 is obligated as base.
But for good things.
For good stuff.
So then the question is, if we pay attention to what our outgoing Commissioner of Corrections said, that Corrections is providing a lot more beyond and what they're not good at. They're good, but that's not their focus. And to really ask our community partners to come up and fill in that void. So is that something that folks here are interested in, really looking at trying to beef up a partnership within the Agency of Human Services between all the departments? And not leave everything to DOC when they're dealing with folks that have been incarcerated. Because let me tell you, people from other entities are not comfortable dealing with DOC folks, dealing with folks from where we entering from an incarcerated setting. I mean, some entities don't want anything to do with that population, so then by default, it falls on DOC to provide either transitional housing or to try to find mental health services or try to find substance use services and treatment.
Good beds. We had that conversation with Rep. Wood this year.
So a lot of money is starting to come out of DOC's budgets to provide these community systems when they should possibly money coming out of the other respective departments. That's been a struggle I've been working on corrections issues since the mid to late nineties, and that was a struggle back then.
So if you haven't resolved.
Okay, I know. If you can't do it now,
Solve it in October.
who's going to, right?
But what piques my interest is the group, the council, the committee that was put together to figure out how do you reinvest those JR2 monies? Could something like that be reconstituted, but not look specifically at the JR2 money?
Yeah,
But the concept of it, which then gives you a leg to stand on in terms of what you want to do.
Whether it's a committee or whether it's actually the commissioners working together, I think plopping it down into the middle of the government that has to implement this, I think probably is helpful rather than having the committee study it again. I mean,
Right, I'm not saying a
Yeah,
committee
no.
study it.
Yeah, I think we've gotten to the point now where we want something to happen.
Yeah.
So my legislative recommendation is going to be to do what I started doing last session, and that is bringing all the commissioners in together into the room and,
Knocking heads.
yeah.
I mean, you can absolutely do that and reconstitute it in any form with whatever charges you'd like.
But so when we took that up in committee, we did have some conversation about whether it should be reconstituted, but whatever it was that we had in front of us wasn't working, and thus the repeal, that we put in earlier.
Was it not working because the money?
Because it was because of the money, that was the focus, even though the language would have allowed more. I think that just needed some more time. If we were going to have a group that was higher level strategic thinking among the different entities to try to deal with this on the restorative side, on the post incarceration, et cetera.
Yeah.
What we had wasn't working out, thank you. Doesn't mean we shouldn't try.
I mean, I'm open to anything, but I know this, some folks were concerned in the Commissioner Demo's exit interview about really feeling DOC is carrying water on a lot of providing services to folks that's really beyond DOC's capabilities.
And there's been legislation that's really kind of started to move some of that, at least the sort of DOC as a pass-through entity of funding, which is why the AG's office now issues the grants for diversion providers.
Yeah, for pre-adjudication.
Right. So it was all coming through.
Yeah, I mean, I think there's a bunch of things. I think about the public inebriate program as well. I mean, that's, we've had designated agencies opt out of that now in Chittenden County.
And more.
And Lamoille, and that's because we weren't paying for it essentially, and they couldn't afford to continue it. But that doesn't mean that those people aren't still there and they're being transported to correctional facilities. And I didn't want to chime in on the transportation conversation, but oftentimes there's, they may be, taken there from Burlington and go to St. Albans and then overnight, and then they release the next day to, maybe they have a ride, maybe they don't have a ride. So, I hear what you're saying. And supposedly BDH and DMH are coming back with an update on their efforts to reestablish, that service, and that will, again, and those are people who get that same medical review and all of that kind of stuff too. So there are linkages, through other departments in AHS for sure, that are, ending up in DOC's services, that shouldn't be there.
But by default, that's where they end up.
I think it's worth mentioning too, that a lot of the providers and community partners themselves, like we're talking about grants and some base funding that go through grants, but their testimony has been pretty consistent in the sense the grant model is difficult for them to operate under. They operate sort of on a year-to-year basis. Level funding isn't necessarily considered level funding for the next year, as we all experience prices go up. Right.
Some grants may not allow them to use the money for folks who are under corrections custody. We don't know.
The conditions of the grants, yeah.
Conditions to those grants. So is this something that the committee is interested in making a recommendation at all or not? I mean, it doesn't matter.
Well, the final report of that advisory council did make some funding recommendations to explore, for instance, like the levy of charges and fees and surcharges and fees in courts to go to specific programs. They were saying they recommended to essentially examine whether those fees and charges should still exist for those purposes and maybe to reassess it that way. So there's been some work done that I think you all could look at and examine when formulating policy ideas, if that's of interest.
I was gonna just say, it would be great to see that report, so we know what exactly is there.
I can circulate that around.
That'd be great.
Why don't you do that for our October meeting?
Right, I got a meeting to go to.
Well,
I'll see you there.
Anything else before we finish up today? So October 9th is our next meeting, and we will work then and make it about, we'll work on, to